Good afternoon, everyone, and welcome to webinar 5 of Schedule School. Today we are covering loss of earnings. I am joined by my co-host Jamie Hill from 9 St John Street and William Latimer-Sayer QC. William specialises in catastrophic personal injury and clinical negligence work. He has a special interest in quantum and is the general editor of Schedules of Loss Calculating Damages 4th edition, which is the leading practitioner text on schedules of loss. He is the current chairman of the Ogden Working Party, who produce tables used by all judges and practitioners to calculate damages, and he is the general editor of Sweet and Maxwell's Facts and Figures. And I'll pass over to you, William.
Well, thank you very much, Demi. I'm going to speak about loss of earnings, as Demi has explained, and this is what we are intending to cover this afternoon. So general principles, we're going to do a run through of all the main principles you need to bear in mind when setting out a schedule for loss of earnings. We're going to look at Penny Foster, who, as you know, is our case study, her past loss of earnings calculation, then her future loss of earnings calculation, and finally, if you get the opportunity to consider periodical payments, the sorts of things to bear in mind when you do that. So this is the case summary. Demi or Jamie, did you want to come in here, or are you happy for me to deal with the case summary?
Yeah, I'll jump in here. So as many of you may have seen, Penny Foster, who was born in May 1983, was involved in a road traffic accident and seriously injured. The main point for today is that the accident rendered her paraplegic and she's now a wheelchair user. And before the accident, she worked as a primary school teacher. The full details are set out on the slide and are also available on the Schedule School website. But for our purposes today, the fact that it's loss of earnings claim, they're the key features for our purposes.
Well, thank you very much, Jamie. And one other point you can see from the slide here that we'll be using for the calculations today is that we've got a joint settlement meeting in the diary where hopefully we're going to be able to resolve Penny's case, and the date is being set for the 17th of March next year. And those who are eagle-eyed will see that that's 3 years from the date of the accident, just to make the calculations a little bit easier. So moving on, general principles. The most important thing is to keep in mind where you're going with the loss of earnings claim. So we start with getting hold of documents, and that can be quite a tricky and lengthy process. You ascertain what the basic pay is that the claimant's earning. Then you look at perks and benefits. What other elements of pay that the claimant might have been entitled to that you can recover. Then you ask about promotion prospects and seek detailed instructions on those, and we'll be considering those later, before being able to work out what the appropriate multiplicand and multiplier is for the earnings that the claimant would probably have received in the absence of the injury. And then lastly, you look at the multiplicand and multiplier for residual earnings, i.e. what the claimant's now likely to earn in the presence of their injuries, i.e. after the accident or after the negligence which has led to their injuries. So one can see in terms of 5 and 6 is actually a 3-stage process. You calculate the multiplier and multiplicand for the but-for injury earnings, then you calculate the multiplicand and multiplier for the residual earnings, and you deduct one from the other. And we'll be seeing that as a 3-stage process in other aspects of calculating loss of earnings. So moving on to documents, this is probably the most crucial part of any loss of earnings calculation. And there are a large number of documents to obtain before you can properly decide how best to present the claim and to calculate what the claimant's loss of earnings is. So firstly, it's sensible to try and obtain the contract of employment, because that will set out the terms of the claimant's employment, hopefully set out what they've been paid, their holiday pay, and various aspects of entitlement. So in particular, any benefits that they might be entitled to. Pay slips and P60 is probably the most important document in terms of working out monthly and annual pay, and also looking for historical trends, and also very useful for calculating averages, either annual averages or 3 monthly averages, or indeed a more favourable average if you're looking at seasonal pay in some cases. Occasionally, you will be representing someone who's self-employed or runs their own business, in which case you'll need business accounts, and you'll need not only their profit and loss accounts and any information you can get from their accountant, but also tax returns. And indeed, sometimes, if it's important, you might need sales documents, so all the underlying documents which go into the profit and loss accounts. Going back to those who are employed, if there are prospects of promotion or career advancement, then you will want to have a look at other documents which may be kept by employers dealing with such issues. One example of that is annual appraisals, but there may be separate promotional files, and it may be that employers keep a separate folder on applications made for promotion and any assessments that are made during that process. And then the last two aspects of documents, which can be quite bulky in terms of disclosure, personnel records. So that deals with the application, initial job interview process, and all the documents that might relate to what's happened to date with that person's employment. And then lastly, occupational health records, if they've been unwell and needed to contact occupational health, perhaps they've had some time off, and that will need to be explored in case it's a problem that existed beforehand and was going to reoccur and cause difficulties with future employment. So the key principle when assessing loss of earnings is that the loss of earnings claim should be net. So although a lot of documents will set out what the gross entitlement is, the claimant can only claim for the net loss, which is net of tax and net of national insurance. Set out there, the British Transport Commission against a Gourley case. So how do you calculate what the net loss is? Because sometimes you might just be told by the claimant that their gross salary was £20,000 a year, and they're not entirely sure what the net equivalent of that is. Well, there's two main ways. The first way is to use facts and figures, because there are set out in a number of tables lots of figures to allow you to calculate gross to net. And one easy way of doing that is to just look up 20,000 in the table, and it will give you the approximate net equivalent. The other way is to use a web program. So for example, Listen to Taxman is a freely available online resource. And essentially all you do is you type in £20,000 into the box saying gross salary, press the return button, and it tells you what the net figure is. And that's quite a useful resource to people undertaking calculations in schedules of loss and putting together loss of earnings claims. Next, well, how do you calculate what the claimant's earnings would have been if you're not quite sure what a bricklayer or a bus driver or a lawyer would have earned? And maybe you're representing a child or a young claimant who hasn't quite got into the employment market yet, hasn't started a job, and you're not quite sure what it is that they'll earn longer term. Now, the easiest and best way is to look up in the annual survey of hours and earnings what an appropriate average figure would be for the area of work that is in question. Now, I'm pretty sure you would have considered the annual survey of hours and earnings in other seminars, in particular the care one, probably referred to ASHE 6115. Now, ASHE 6115 is the specific category, special occupational category for home helps and carers, home carers. And there are lots of other SOCs or special occupational categories for all other types of work. So whether it's a lawyer or might be a bookkeeper or an accountant or a whole host of other jobs, particularly obviously paid ones, because it's done the surveys on a PAYE basis, so it's only for those who are employed rather than self-employed. But when we look at how much people are going to earn, it gives you a very good indication as a rough average estimate, taking into account benefits and bonuses, but it can be disaggregated. So whilst it gives you an average figure for the UK overall. If you have a claimant who works, for example, in Leeds or Manchester or London or one of the other main city centres where earnings might be somewhat higher than outside, you can disaggregate by looking up on the Office of National Statistics website, and there's an example here. You can download an Excel document which will set out the earnings separated and giving more detail for specific areas of the country. It doesn't always work out, and sometimes if you've got a client who lives miles away from anywhere and in the sticks, then if you do that, it's probably going to reduce their earnings. So you may be better off taking the average. But sometimes, particularly with people living in the capital, then it's worthwhile doing because the figures will be somewhat higher, and obviously because of the cost of living are higher as well. Perks and benefits. Now, I hope you'll see from these pictures that there are obviously some benefits which are pretty clear, such as a company car or maybe permanent healthcare insurance, so private medical, or maybe free gym membership. Now, all of those types of perks and benefits might have a financial value, and those can be built into the claim, because if the claimant loses that job and then loses that perk or benefit, it's a valuable financial loss which can be recovered. And in terms of how you present it in the claim, there is a form called a P11D, and that's another document to be looking out for. Sometimes there won't be one because there's not a significant benefit which needs to be taken into account. But often with professional jobs, there'll be a P11D setting out what the allowance is in taxable terms, and that can then be added to the schedule and claimed as a perk and benefit. The house, as you'll see in the bottom right-hand corner, relates to some people who get extra living allowances, perhaps a bonus for, again, living in the capital. Alternatively, they might be given amounts to go towards renting or purchasing properties in some cases. So promotion prospects. This is perhaps the trickiest area to advise upon because a lot depends upon the individual facts of a case. And sometimes there aren't any promotion prospects if the claimant worked in a factory and had been working in the same position for 20 years and was likely to continue in that job for the foreseeable future and wasn't keen to become a manager or progress their career. But in other cases, there might be a real possibility of advancing up the career ladder, in which case you'll need witness statements. Now, often those witnesses might be managers or people at the same level who have advanced their careers themselves. And there's an accepted difference in relation to witness statements from those people where they're giving an opinion about where the claimant might have got to and their chances of success in promotion, that although it is opinion evidence, it's something that the court accepts as valid and is admissible in evidence, because otherwise the claimant wouldn't be able to establish a loss or show what the promotion prospects would have been. But I'll go on now to look at employment consultants, because often it's said that employment consultants can assist with assessing loss of earnings claims. The slight difficulty, though, is that although a lot of employment consultants will tell you that, actually judges really don't like them. And because of the availability of ASHE, the Annual Survey of Hours and Earnings, and also a lot of other information online now, courts will say, well, it's perfectly reasonable to have the data, and they don't mind looking at the individual figures, which might be available from various databases or that employment consultants provide. But what they don't like is the employment consultant at the end of their report saying, in my opinion, the claimant would have got to X, Y, and Z and would have become the CEO of a company, having never met them and having, or occasionally only spent an hour or two with them, but not having expertise or a lot of experience in a particular field. And what I would suggest, and you might want to bear in mind when considering more complicated claims, is that employment consultants can be very useful in terms of providing the data, and you can put that in a witness evidence. So you can get the employment consultant to say, I have been asked to research the earnings potential of claimant X. I have looked in X, Y, and Z databases. and these are my findings. And then you put them in a witness statement and get the evidence in that way. And I've had a number of cases, as long as you keep it factual, most judges are pretty content with that. But it can be useful, I think, 2 or 3 types of case. So the first case is where you've got someone, I had one recently, who wanted to be self-employed and work as a bike repair specialist. And there isn't a category in facts and figures or in the actually database for bike repair people working in a self-employed capacity. There are some suggested earnings for those working at PAYE, but not on a self-employed basis. And secondly, it might be that you've got someone who is a banker, for example, and was a high flyer and was hoping to be promoted. They might have already been in quite a senior managerial position and wanted to be promoted up and become chief financial officer or CEO. And there just isn't the data in the standard databases to deal with those types of cases. And then you might want either some headhunters to give factual evidence or an employment consultant. And then lastly, sometimes it can be quite difficult to assess residual earning capacity. And that's when employment consultants can be quite useful in terms of advising upon what a claimant might be able to achieve in the future, given their injuries. And sometimes they can give quite helpful information about the claimant's locality and the difficulties of finding work, particularly for those with injuries. But generally speaking, I think you should be cautious, as I've explained. Moving on to comparators now. So one of the best ways of establishing what a claimant's loss of earnings is as a result of accident or injury is to find a comparator. So it might be that you've got someone in a fast-moving company who says to you, look, if I hadn't been injured, I would have been promoted. Look at X, who was in a similar position to me at the same time of my accident, and they've gone on to wonderful and fantastic things, and they're now earning a huge amount more than I was. And it'd be wrong to just see me as being static. And this person is a really good example of where I would have got to. Now, that's all well and good, and definitely something that should be considered in many cases if it's difficult to establish what the claimant's earnings were likely to be, likely to have been in the absence of the injury. However, the most important thing is obviously choosing the right comparator. And this is where you get into some disputes with the other side. It may be that you pick someone who is a very accurate comparator. They were exactly the same in terms of level at the time of the injury. They've had a similar background and had similar promotional prospects. But obviously, you can fall into some difficulties where you pick someone who was very different in terms of their background and abilities, and the other side can quite clearly undermine that and say, no, this is someone who had a much better career profile and was likely to have succeeded in promotions and furthering their career in a much more enhanced and intensified way than the claimant. So when you're selecting a comparator, it may well be helpful to have comments from the manager or other people to confirm that your selection of X is an appropriate selection. So moving on to more difficult cases now, and probably the 2 most difficult ones that we see are those involving the self-employed and businesses, and those involving an assessment of loss of a chance. So looking first off at the self-employed, there is a test in terms of recoverability, and it's a 2-stage test which comes from a Court of Appeal case called Daru against Evans, which is 1996 PIQR Q23. That's again 1996 PIQR Q23. And the 2 stages are that firstly, the claimant must prove that on the balance of probabilities, they would have entered into the business venture or were in it already, and it probably would have been profitable. So that's the first step. And then secondly, the claimant must then go on to produce evidence to show what the profit would have been, and the court assesses the nature of that profit. So you only get off the ground if you can show that the business venture was viable, essentially, and was likely to make a profit. But if you can do that, then you can go on to assess the loss of a chance. And the loss of a chance, the famous case is Doyle against Wallace, and that was a case involving a claimant who said that they wanted to be a drama teacher, and that would have significantly increased earnings to the claimant, and the court assessed a 50% chance relating to the prospect of becoming a drama teacher and thereby increasing earnings. But there's also lots of other cases where it's been used, and it's not restricted just to 1 or 2 chances. It can be used in cases where there are multiple chances. So again, the very well-known case is the kickboxer case of Langford against Hebron, and that's a 2007 case, Court of Appeal case, where the claimant suggested that in the absence of injury, he would have been able to go on and become world champion and set up dojos all around the world. But there was a number of different chances. So at the first level, the claimant might have just kept his dojo going and been reasonably successful. Then the next level up was becoming world champion. Next level up was several national dojos, and next level up, it got more and more successful and complex. And what happened in that case is the court allocated different percentage chances to each of the different levels of success, and then a calculation was made on that basis. However, it's usually reserved to cases which involve a lot of different prospects where there's a significant increased enhancement with each additional element of success. So the only cases really that it gets applied in are the type of kickboxer case where someone might have enormous additional earnings if they go up a level in terms of their business, or professional footballer cases. And then you have an interesting debate about whether they would have been in the Championship or Premier League, and then which team they might have been playing for, and whether they would have been able to generate a lot of additional merchandising sales, or being able to promote their brand and their name such as to increase their annual earnings. The other point to note in terms of loss of a chance is that when acting for claimants, sometimes you have a client who is in the civil service or in the army, for example, and they might have a very a clear hierarchy in terms of promotional prospects. And so, for example, in the army, there'll be lots of different levels or ranks that the claimant might be able to get to. And the courts are generally taking quite a pragmatic approach in those cases. So rather than applying lots of percentage chances to each of the individual ranks, if the claimant adopts what's called a reasonable career model, then it's possible to put forward the claim on the balance of probabilities. Now, the reason for that is that you're considering lots of different levels, and it becomes quite a complex and convoluted calculation if you have to set out all the different percentages, and there's often a big debate and dispute about what those percentages should be. But as long as you pick a reasonable career model and pick the rank to which the claimant was likely to go to, and often you can get evidence from this from the army themselves, and that they'll keep a database about the number of people who get up to certain ranks given their age and position in the army at the time of doing the assessment. And the idea about the reasonable career model is that the claimant might, on the balance of probabilities, have got to a certain rank, say major, and whilst there was a chance of being promoted higher, equally that is offset about the chance of not getting promoted to that level. And so as long as a reasonable career model is chosen, generally speaking, most judges are quite keen to adopt a pragmatic and more straightforward approach to the calculation and avoid the more complex percentage loss of a chance model. So those are probably the two most difficult areas that we end up dealing with. And I'm going to move on now to looking at the multiplier. So all of this slides up to now, I've really been looking at the multiplicand and the annual earnings and whether or not you need to consider any increases to those. The quickest and easiest way to check the multiplier, i.e. the age at which the claimant is going to retire, is to get on the government website and use their state pension age calculator. And all you do is you get it up on screen, and you can just Google state pension age calculator, put in the claimant's sex, and then put in their date of birth, and it will give you their state pension age. Occasionally, a claimant might tell you that they were planning to work longer, maybe 70, 75. And I was speaking to a colleague the other day, phoned for advice, because he's got a client who's an artist, and he is suggesting in that case that the artist was going to continue working for life, and they weren't going to stop at age 70, 75 or 80. They were just going to keep on producing pieces of art until they dropped, in which case you use a life multiplier. But that's a very unusual case, and not one I've come across. But generally speaking, use the state pension age calculator, and that will tell you their pension age, and then you go to the Ogden tables and look up the relevant table. So the most important aspect of calculating the multipliers and then doing the stages 5 and 6 calculation on our roadmap earlier is to look at whether or not the claimant is disabled. And we use under Ogden a specific definition of disability, and it's got 3 aspects to it. So does the claimant have an illness or disability which is expected to last for 12 months or more, i.e. a year, or is it a progressive illness? Secondly, is the Disability Discrimination Act 1995 definition satisfied that the impact of the disability has a substantial adverse effect on the claimant's ability to carry out normal day-to-day activities? Pausing there briefly, it's the 1995 Act definition which is used because the data for the tables indicating discounts for contingencies is based upon the 1995 Act definition. So it's because the research is quite old that we're still using that definition rather than the new Equality Act definition. We need to update it, but it's getting difficult to find the researchers prepared to do the further work on it. They're all very busy. The third element is the effects of the impairment limit either the kind or amount of paid work that he or she can do. So not only have you got to meet the definition for being disabled and it being a condition lasting more than 12 months, it's got to limit the type or kind of work that the claimant can do. So it's very important to consider whether a claimant meets that definition, because if they do meet it, you can undertake an Ogden calculation, which is likely to be more beneficial, a more favourable outcome in terms of the calculation than if they don't. Because if they don't meet the definition for being disabled, you might be limited to a Smith and Manchester or a Blamire type award. Now, scheduled school is based upon a catastrophic injury scenario, so generally speaking, it shouldn't be a problem in these cases, but occasionally you do get into a dispute or debate about whether Smith and Manchester or Blamire award might be more reasonable for a particular individual. And I'll come on to that in a moment. So Ogden tables A to D, this is the main discount that gets applied in loss of earnings claims. So when you bring a case for loss of earnings up to retirement age, no one is impervious or able to withstand working up to age 65, avoiding any risk to employment at all. And what the Ogden tables do is set out contingencies or suggested discounts for contingencies other than mortality. So that's the risk of not being able to work up until retirement age, the risk of being made redundant, the risk of suffering a nasty injury or being hit by a bus or suffering something like cancer, which then prevents the possibility of working. Tables A and B are for men, and tables C and D are for women. And in relation to tables A and C, those are the suggested discounts for people who are not disabled, and then they're split into employed and not employed. And then tables C and D, sorry, tables B and D apply to those who are disabled. So what you do, as I was explaining earlier, is you undertake a calculation of the multiplicand that relates to the claimant's earnings pre-injury, and you multiply that by the pre-injury discount factor, either from table A or table C, whether it's a man or woman, and then you undertake a separate calculation relating to the position post-injury, and you take the post-injury earnings multiplicand and you multiply that by either table either table B or table D. So either the table relating to men who are disabled or the table B relating to women who are disabled. I put there a little reminder to myself about adjustments to the suggested discount factors. That's a whole talk in itself, so I won't go into any details there, but occasionally you can persuade a court that the discount factor that's suggested in the tables is either too high or too low. And what you need to do is establish good reasons for that, not just because you don't think they should apply, but because, for example, the claimant had been in a job for 10 years and never taken a day off work. It was a sedentary role, and it's very unlikely that they wouldn't be able to perform it in the future. And it's a very safe environment where there's not so much changeover of staff or a risk of redundancy or losing employment. The alternative, obviously, is that where you've got someone who's been in and out of work multiple times, keeps losing jobs, or there's perhaps they're in a real hazardous area of work. Maybe they're a firefighter, or maybe an engineer for fighter planes or something, or a test pilot who has had numerous crashes in the past. Then it might be that you could justify a higher discount. So what I mentioned earlier was that where someone isn't disabled and they don't meet the disability criteria, then it may be you would be stuck with a lump sum award, which is likely to be less favourable. And there are two types of awards to be aware of. One is a Smith & Manchester, so that's an award for disadvantage on the open labour market, and that's how we used to approach a lot of these cases beforehand, rather than the Ogden approach. And then the other is a Blamire award. So Smith & Manchester is a sort of finger in the air for assessment of all the effects of injuries in the future. It's usually an underestimate. It's usually based upon a multiple of the claimant's net earnings. So if the claimant was earning, say, £20,000 net a year, then often the judge might award 1, 2 or 3 multiples, so 20, 40 or £60,000 as a Smith & Manchester award to cover all aspects of future disadvantage on the open labour market. A Blamire award is slightly different, and that includes a Smith & Manchester element, but it also includes an estimate of loss. Now, it can be past loss or future loss, or all three, so past, future and Smith & Manchester. So it's a sort of finger in the air, very broad estimate that judges occasionally make. And the reason why they make awards like this is because of what they call imponderables, i.e. that there are so many uncertainties in a case that it's just simply not possible to use a multiplicand approach. But it's usually much better to avoid a Blamire award if you can, because the Ogden multiplicand approach is the conventional approach and usually ends up with a much better result. So the final slide, I believe, before we move on to look at the case study, relates to other discounts. And other discounts usually involve travel expenses, uniform or clothing expenses, and occasionally tools and other items that the claimant might have needed to buy on a regular basis to perform their work. In terms of travel expenses, the high watermark for defendants is a case called Eagle and Chambers, where 15% was discounted. But there is a case that you should be aware of called Dues against National Coal Board, where the House of Lords in that case essentially said that unless they're significant, so for example, if the claimant was travelling to work by helicopter, then they shouldn't really be taken into account. And there are a few cases which have followed that and said, well, if they're only a few £100s a year, that they're ignored. And there's a very helpful case that I was involved in a few years ago called Totham against King's College Hospitals, where the claimant came from a very professional background. It was a cerebral palsy case, and the argument was that although there might have been significant travel expenses in the future living in London, that was offset by the potential benefits that the claimant was likely to have earned in addition to pension. So loss of earnings and pension were claimed, but we didn't put anything forwards for perks and benefits. And the argument was that although there might have been some travel expenses and work clothes and other expenses related to the employment, that was more than offset by the fact that no claim had been brought for perks and benefits. Tools is often taken into account in self-employed calculations anyway, just in terms of the expenses of the business. So you just need to be careful that's not a double recovery. And in terms of clothes, often you might suggest that that's something that should be looked at under a separate head, so that if there's some additional clothing costs, then it might be you give credit for the saved work clothes if that's a feature. So moving on to Penny then. The first aspect of the case study is to look at her past loss. And I'm grateful that I'm dealing with loss of earnings in this particular case study, because it's probably one of the most straightforward aspects of Penny's schedule of loss. And I've split it into past and future. So looking at past, it's a three-stage process as we were looking at earlier. A, calculate but for the injury earnings. B, calculate the earnings that she has in fact received. And then C, deduct B from A. So it's that straightforward. I put forward some assumptions here just to flesh out the case study a bit. So we've got gross earnings of 38,500. It's a bit more than the average primary school teacher. So that's gross. And I've listened to the tax man as we were looking at earlier to net that down. You get 29,844 net. And the assumption is that she was paid in full for a year. So till the 17th of March 2020, and then she got half pay until the 17th of March 2021, and then after that, no pay. So that breaks down as follows. So you've got earnings but for the injuries. And what I've done here is I've set out the net for the first year, which is essentially what she was earning at the time of the accident, 29,844. And then assuming that we've done some research and been able to get a comparator or ascertain what the inflationary rises would have been, added in her increase in earnings that she would have had from the 17th of March 2020 and then 17th of March 2021. So that's the 3 years loss of earnings, and that all adds up to 92,932. And then what we do is we calculate the earnings that she has in fact received. So she got full earnings for a year, 29,844. And then for the second year, she got 50%, so 15,432. And then in the third year, she got nil. So you add all that up and it gets you 45,276. And then the calculation is very easy. It's A minus B, which is 47,656. Now, there's one other point to note here, which we haven't discussed earlier, and that is under the contract of employment, it might enable the employer to require the claimant to reclaim any losses or expenses paid following an injury. So sometimes if they've had to pay out statutory sick pay, for example, or have continued paying the employee for a period, they can require, as a subrogated claim, the employee to claim that against the insurers in the personal injury claim. And for the purposes of this example, I've assumed that the amount that the employer would be entitled to is 20,000, and then just added that to the loss of earnings claim, and that gives you a total past loss of earnings claim of 67,656. Now, there's one small point here which might be helpful in some cases. So contracts of employment do often set out whether or not this is something which they require the employee to do. And if they do require it, obviously you can claim for it as a subrogated claim. But there's also a case called Dennis against London Passenger Transport Board, dates back to 1948, where I think it was Lord Justice Denning in that case said that where the claimant feels they're under a moral obligation, that may be enough to actually claim the employer's outlay. So even if it's not in the contract of employment, if the claimant says, well, I really want to give it back to the employer, they've been really good to me and I feel like I owe them, then it may well be something that you can still put in the schedule. So let's look at future loss of earnings now. And the assumptions relating to future loss are as follows. Penny's a teacher. Her average or her normal retirement age as a teacher is 65. Her earnings as at the time of the JSM are continuing at 42,000 gross or 32,224 net. But to spice things up a little bit, she's got a 50% chance of promotion to earnings as a head of department to say £60,000 gross or 43,493 from age 50. And in the future, although she is wheelchair bound, she still has capacity and still very keen to get back to some work if she can. And it's assessed that she has residual earnings of £10,000 gross or £10,000 net to age 50. So she's not expected to work beyond age 50, but if she's lucky, then hopefully she will be able to earn up to about £10,000 on a part-time basis. So it's a three-stage process. So we look at earnings but for the injuries, and the base loss of earnings claim to a retirement age of 65 is 42,000 gross or 32,224 net times a multiplier. Now she's currently aged at the time of the JSM 38.83, so just under 39, and that's to age 65, and the multiplier is 26.51, and we multiply that by table C discount factor, which is 0.88, so a discount of 12%, and that gives you a base loss of earnings claim of 751,747. In addition, you've got the loss of a chance claim, but this only applies from age 50 onwards. And I've allowed 11,269 net as being the extra amount up to age 65, and the multiplier is calculated by taking the multiplier to age 65 of 26.51 less the, which is from table 10 of the Ogden tables, less the multiplier to age 50, which is calculated from table 4. So it's 26.51 minus 11.27, and then you multiply that by the same discount factor of 0.88, and then you multiply it by the 50% loss of a chance. So you get 151,131, and you add those two together. I haven't put any discount in for travel expenses because the argument we were talking about earlier, that there might be some benefits that Penny would have had in any event. Probably not a huge number of benefits as a teacher, but there may well be some benefits that she would have enjoyed. And that gives you pre-injury or but for the injury expected earnings of just over 900,000. And then we calculate the credit for residual earnings, and that's 10,000 gross or net times the multiplier to age 50. That's from table 4 of 11.27. And then it's a different discount because she's now disabled, and we apply a discount factor from table D of 0.41. And that gives you a figure of 46,207. Now, just pausing there briefly in relation to the table D suggested discount factor, a lot depends on the facts of the case. So if she is likely to get work and is already generating some interest, and it seems quite clear that she's very able and will hopefully get some part-time work, then that discount factor may well be perfectly appropriate. But in other cases, so that's a discount for someone not working who's disabled, but it might be that someone who's in a wheelchair and has a lot of other issues, so depression, chronic pain and a lot of mobility issues as a result of paraplegia, and may need carers to help with transfers, etc., it might be quite unrealistic that that person is going to be able to work in the future. And either you can discount the chance of them working at all in the future and say it's speculative and remote and therefore give no credit, or alternatively, if there's still a reasonable chance, or a chance, but it's perhaps less than the average person who might be disabled, you could argue that the catastrophic injury in this case is much more severe than the normal back or knee injury that might be being considered in other cases. Then arguably the discount for contingencies applying to residual earnings should be increased, i.e. the discount factor reduced. And that's a moot point that can be considered on a case-by-case basis. So finally, moving on to consider periodical payments. And just before I pull up, we've only got a couple more slides, but I should explain that most insurers absolutely hate periodical payments generally. They're allergic to them, or are not keen on them because of the difficulties reserving them and the fact they can't close their books, etc. But if you are lucky enough to find an insurer who is willing to consider periodical payments, then occasionally you can get them for loss of earnings. I've had a couple of cases where we've got loss of earnings as periodical payments. You see this, Salwa and Ali was one where he was very keen on working in the city, and it was an average multiple can for life, and the court accepted that it was reasonable to have that as periodical payment. And then in Robshaw, the claimant came from a long line of engineers, and the court accepted that he was likely to have been an engineer in the absence of the negligence, and awarded earnings on the basis of average engineering professionals, and linked the periodical payments to ASHE 212, which is the category for engineering professionals. But the three things to consider is they work much better if you've got a single average multiple can rather than stepped multiple cans or changing multiple cans with promotions, etc. So if you've got one single multiple can that's an average for life, then periodical payments are much easier to account for, as opposed to going up and down at different stages, because it might be that people earn less in the future when they tend to earn less when they start out, then more in the 30s and 40s, and possibly get to a peak in their 40s and 50s, and then they might sort of wind down a bit towards the end of life, which makes for quite complicated calculations of periodical payments. The second thing is you've got to apply the discount for contingencies to the multiplicand, because there's no multiplier, and we don't have any specific discount factors that take that into account, so we just suggest using the same one. But again, it does create a bit of uncertainty as regards what the discount should be. And then lastly, it's selecting the right index, how to uprate those periodical payments in the future. ASHE 50, which is just the aggregate for or average earnings, average median earnings, was used in Salwa, and might be reasonable in some cases. But if you've got a specific discipline or field of work, whether it's a teacher or carer or engineer, then you can use that particular category. And this is the last slide, and apologies because it does look quite complex, but it's actually quite straightforward. So we added some guidance to Ogden to deal specifically with periodical payments, and this was suggested by Richard Cropper and Professor Wass. But what you have is the PP for a loss of earnings calculation is A times B times C, which is the multiplicand pre-injury times the discount factor pre-injury, so that will be either A or C, and then times the index that would apply to the pre-injury job. So if they had a high-profile professional job beforehand, then and so they were educated to degree level and were in employment, then the discount factor C would be at its highest. Or sorry, the discount factor B is highest, so the discount would be minimized. And then you deduct D times E times F, which is the multiplicand post-injury, which might be a lot less. It might be part-time work doing a much lower level of employment, working in sort of admin type post or secretarial type post, times the discount. So it's D is the multiplicand times the discount factor, which applies as a result of the injuries. So it's table C or table B or table D. So the table which applies to men if they're disabled, which is B, or women who are disabled, which is D, times by finally the index, which is now appropriate. So if they've had to drop down in terms of their job that they do, and they're now doing one much less demanding and much less rewarding, then often the index will have to change. So it might be that it's now related to admin workers or part-time workers, and the likelihood is that that index will increase at a much lower rate than a high-profile job in the city beforehand. But as I say, fortunately, this isn't something you're going to have to consider on a regular basis, because insurers really don't like periodical payments, and even the NHS isn't being keen on them for loss of earnings claims. So unless you're very lucky, you won't need to grapple with this equation, but I just put it in here for completeness. Now, I think that completes the training today on loss of earnings. But Jamie or Demi, was there anything else you wanted to cover, or do you have any questions that you think it might be useful to raise before we sign off?
Just in terms of what we were dealing with there on periodical payments, you mentioned that the insurers don't like them. For a claimant such as Penny Foster, what advantage would there be for her for having a periodical payment for her loss of earnings, if any?
Well, it's a good question, Jamie. I think a lot depends upon what she would like to achieve, and sometimes there's going to be a shortfall from the accommodation claim and other aspects of the claim, and she would prefer to have a larger lump sum for flexibility and for contingencies. So she may not wish to have periodical payments for loss of earnings. However, if she's already bought her house and adapted it, and what she really wants is a guaranteed ongoing income stream, like she would have had in terms of earnings, then some claimants are quite attracted to their earnings being paid by way of a periodical payment. And it's a net figure that is guaranteed and continued for as long as the loss of earnings claim is pleaded for. So usually the retirement age of 65, 67, 68. And it means that she doesn't have to invest a large proportion of her damages. So for her, she can have the peace of mind that that money is just going to keep coming in each year. She doesn't have to invest it in stocks and shares and risk those decreasing. And the second thing is that it will go up by a good index. So historically, earnings-based measures, so if it's linked to an earnings index, as it probably would be because it's earnings loss, then it will go up faster than prices. So at the moment, inflation is going up a lot, and historically, earnings have tended to rise faster or at a faster rate than prices. So over time, it's a very good and attractive financial product to have. You can't go on the market with a lump sum and buy an earnings-based annuity. So you can't actually get a actually 6115 annuity at the moment. I know people are working on it, but there isn't a product available as of now to buy. And likewise, you can't get one linked to teachers' wages or engineering professionals' wages. So it's a very attractive and useful product to have. And you can't actually go out and buy one. So if you can get an insurer to agree to it and the client wants it, then I think a lot of IFAs would say, yeah, grab it. It'd be very useful for them to have.
Thank you. That's very insightful. Demi, was there anything that you wanted to comment on?
No, I think everything's been perfectly explained, William. So I just want to say thank you for joining us. I think this has been a great webinar and be a great resource for everybody. And as everyone knows, Schedule School is a free resource, but if you do find our webinars useful, please consider donating to the Spinal Injuries Association. And I think that's everything from us today, and we hope to see you all on the next webinar.